is the year of the Universal Periodic Review of India, and the process has started from the month of May, and many members of the United Nations have already placed before India a list of recommendations which needs an implementation. But the track record, that is before the international community and before the people of India and the people of Jammu and Kashmir, is that the UPR 2004 recommendations still remain unimplemented. One more thing that is very important to be understood is that India asks the world to perceive it as a garden of democracy. But the stunning reality is that Indian democracy fails in the acid test of democracy. I will give you an example. Mir Vaizumar Farooq is here as a witness to the fact that the political space to our leadership is gradually sunk and they are continuously kept under house arrests, number one. The second thing is that the Muslims of Jammu and Kashmir and other people living there, they have one right that is called the right to religious practice. This year, after month of Ramadan, when all the Muslims went for Thanksgiving prayers, our leadership was denied this opportunity to pray, and they were kept arrested in their houses. So this needs to be perceived that Indian democratic practice stops at Lakhanpur, and this democratic practice we don't find in the state of Jammu and Kashmir. But since today the topic under discussion here has been Convention on Torture and about the International Convention on the Forced Disappearances. So I will just try to make 4 points in this regard. There are 4 issues of concern that remain critical to the situation in the state of Jammu and Kashmir. Firstly, the issue remains that Jammu and Kashmir is highly militarized and empowered with black laws, and these laws have been described by the panelists, and the most disastrous laws are the Armed Forces Special Power Act and the Public Safety Act, which empower the state to have administrative detention, and there is, you can detain for an unlimited period of time anybody and put him behind the. This is inhuman, unethical, immoral, unjustified legislation, and the world community in the recommendations is also demanding of India to revoke this insanity that is prevailing in the state of Jammu and Kashmir. The second thing that remains in focus is that Government of India's failure to expedite the ratification of the Convention Against Torture and other cruel, inhuman, degrading treatment or punishment, which normally is called CAT, which is an international human rights instrument under review at the United Nations that aims to prevent torture around the world. The convention requires the states to take effective measures to prevent torture within their borders. The Government of India has made an unsatisfactory attempt in ratifying this convention. Furthermore, in May 2010, Indian government produced the Prevention of Torture Bill, which was passed without a debate or consultation with stakeholders. However, this bill failed in complying with international standards as well as India's obligation to prohibit torture and ill treatment under International Covenant on Civil and Political Rights. During the review, member states, including Australia and United Kingdom, expressed their concern to the Government of India who had not yet ratified the Convention Against Torture, despite accepting the recommendation to do so in the last UPR, and highlighted the fact that the draft Prevention of Torture Bill is inconsistent with UN Convention Against Torture in a number of areas, including the basic definition of the word torture. Czech Republic stated that India must expedite ratification of the Convention Against Torture and its optional protocol. Canada also spoke their concern that India has not yet ratified the Convention Against Torture and further encourages India to pass the Prevention of Torture Bill and to allow the visit of UN Special Rapporteur on Torture. Key issues concerning the Prevention of Torture Bill: the definition of torture itself, failing to identify involvement in investigation of acts of torture through lack of wording. It does not ensure that all forms of inhuman and degrading treatment are under the scope of the law. Number two, statutory immunity is given to public officials, allowing law enforcement officials and security forces virtual immunity against prosecution for perpetrating the torture. And the third thing is inadequate time limit given to the victims to file complaints. The third issue concerns the dilemma of missing persons. During the 2008 Universal Periodic Review, it was recommended that India expedite its ratification of the Convention on Enforced Disappearances, which is an international human rights instrument of the United Nations to prevent forced disappearances defined in international law. Crimes against humanity. In accepting this recommendation, the Government of India stated that the process of ratification was underway. However, there are no signs of a process of ratification, because the human rights policy designed by India is based on torture. All the violations, all the human rights violations that we are talking about are a consequence of torture. The enforced disappearance is a consequence of torture. Mass graves is a consequence of torture. So their whole policy to subjugate people is revolving around this torture. So they are not complying with the recommendations that were made to them by the international community. Lastly, further investigations and attention must be made towards extrajudicial killings. You know, mass graves is a matter of great concern. Human bodies dumped in darkness of the nights should not be condoned. It needs to be debated in all international fora. And I must congratulate the European Parliament for having already put an urgency resolution. What is required? What is required is that other bodies, other international institutions also need to take cognizance of this grave violation of human rights in the state of Jammu and Kashmir. And here I must also welcome the statement made by Christoph Heinz, the United Nations Special Rapporteur on extrajudicial summary or arbitrary executions, who confirms that the Government of India have indeed created illegitimate laws in relation to Jammu and Kashmir. Chris Heinz conducted a 12-day fact-finding mission into the Indian-occupied Kashmir in relation to Armed Forces Special Power Act 1958. He stated, a law such as AFSPA has no role to play in a democracy and should be snapped. The repeal of this law, of this will bring domestic law more in line with international standards. To conclude, I may say, instead of honoring UN pledge, India claims that Kashmir is an integral part and continues its reign of terror, continues its policy of death and discipline. On the hapless Kashmiris, it is time this insufferable practice ceases and Kashmiris enjoy the freedom they aspire for. It seems paradoxical that in spite of the gross human rights abuse, India is being accepted as a legitimate democracy, which seeks her place in the Security Council of the United Nations. The premise and structure of impunity connected to militarization and corresponding human rights abuse bear witness to the absence of accountability inherent to the dominion of Kashmir by Indian states' refusal to take seriously the imperative of addressing these issues as the only way forward to just peace in that region, because Kashmir is an international issue and is one of the burning issues in the region of South Asia. Thank you very much for doing that.